Okay, and now we are at 2 o'clock. And after this little break, I hand over to our moderator for the debate, should EU member states fix the Energy Charter Treaty or withdraw from it, to our, moderator, Jennifer Baker. Thank you very much for moderating this debate with us today.
Thank you very much, Francesca, and welcome to everyone just joining us now for this important debate on the Energy Charter Treaty, hosted by Friends of the Earth Europe and the Climate Action Network. So, as Francesca said, my name is Jennifer Baker. I'm a journalist and presenter based in Brussels. I'm not a topic expert, but I am your moderator for today to try and steer your questions to our panel of experts who really do know what they're talking about. Today's debate is especially timely as there was another round of negotiations at the beginning of this month and another scheduled for the beginning of June. So the overall question we're trying to answer today is whether EU member states should try and fix the ECT or withdraw from it. We'll start by looking at the main criticisms of the ECT in its current form. And remember, it is almost 30 years old, and back when it was created, it was not really created with a climate combating action in mind. So one of the biggest areas is, of course, the Isds mechanism. That's the investor to state dispute mechanism, whereby foreign investors into a country can sue the government if they make changes to the law and their projects that could hurt profits. We've seen a recent uptick in the fossil fuel companies taking this action. In recent cases, we've seen rock hoppers suing Italy for 225 million euros, and the RWE case in the Netherlands runs to almost 1.4 billion. So it's huge amounts of money at stake. So it does give countries pause. The second big problem is whether or not it is in fact compatible with the Paris Climate Agreement, or whether it is simply not compatible with global climate action changes. And it's worth noting that the EU is currently the only contracting partner that is suggesting a phase out. So we'll look at the state of negotiations, what can be done, why delay is no longer possible. So that's what we're going to talk about today. I hope you've all got your questions at the ready, because we do want some great engagement with you. And with that, I will tell you that there is translation into French and into Spanish. You can go down to the bottom of your screen. There's a little globe icon. Click on that and click the language that you want to use. So please also, if there was a Q&A function, you can use that to send your questions to our panelists, and we'll do our very, very best to answer as many of those as possible. Remember, if you do click the translation button, also mute the original audio so that you're not hearing two different languages in your earphones. And with that, I'm going to introduce you to our panelists, because we are very, very pleased and honoured that you've joined us today, ladies and gentlemen. We have Claude Turmes, Minister for Energy and Minister for Spatial Planning from Luxembourg. We also have Alexandra Tomczak, who is the member of the cabinet for the first Vice President of the European Commission, Frans Timmermans. We have Nathalie Bernasconi-Osterwalder, Executive Director of IISD Europe. We have Olivier de Schutter, Special Rapporteur on Extreme Poverty and Human Rights, and Aurore Lalucq, Member of the European Parliament. Ladies and gentlemen, thank you all so much for joining us. Let's start with a sort of first opening round question to all of you. What are the reasons we need modernization, and what is the state of the modernization from your perspective? Claude, I'm going to give you the floor first.
Good afternoon. Thank you for inviting me. So I think it's relatively obvious that this treaty, which comes from the early 90s, was a fossil fuel investment treaty. That was how it was conceived at the moment when the ex-Soviet Union broke down and when Western European companies tried to move into investments, especially in the ex-Soviet Union countries. It's not at all a hazard that Netherlands drove that story at the time, because there is one of the big oil majors is a Dutch-British company starting with an S in the name. So that was basically, that was the driver. And it's clear that the treaty as it stands is in complete so in a crash with Paris. And I think our problem was that very few officials were aware of that. And I think all of us who are present today, I think we have at least the merit that we have been able to bring something to the top political level and to media attention, something which even a year ago, even when I raised it at the energy ministers, there were energy ministers sitting at the table who were not aware of that treaty. So we have, I think, moved the show, and then later we will come to the issue, have we moved it far enough already? So, but that is probably in a second round question.
Alexandra, let me turn to you then. So the ECT is undergoing a modernization. So why does the EU see problems with it in its current form?
Yeah, well, thank you very much, Jennifer, and apologies on behalf of Diederik Samsom, who couldn't join the meeting today. I think it is very clear with the European Green Deal that the energy landscape has to change completely. Well, it has to change completely by 2050 when we're going to climate neutrality, but also by 2030. And we now have a political agreement to have a 55% reduction in greenhouse gas emissions over the next 10 years. And that means that even though fossil fuels are still going to be present in 2030, in 2050, we have no more space for coal. We have almost no space for oil and a marginal role for natural gas. And so that leads clearly to a need to align a treaty on investment protection, such as the Energy Charter Treaty, to a big need for modernization in order to align it with the European Green Deal, but also with the Paris Agreement. So this is, for the European Commission, this is really the first objective, to align it with the Paris Agreement and with the Green Deal. But there's also another objective, which is to do with bringing the treaty in line with modern international standards when it comes to investment protection and investment dispute settlement, which you have already mentioned. So there are these two objectives that we are pursuing, and the negotiations have started last year. Last year, we have focused more on the trade-related elements of the modernization. This year, as you know, in February, we proposed a new definition of economic activity, and that takes us more into the discussion on, for the energy sector, what does the alignment with the Paris Agreement mean? But there is absolutely no doubt that we need to bring the treaty in line with the new objectives, which have changed with the Green Deal.
Olivier, as you heard Alexandra say, that it must be brought in line with the objectives of the Green Deal. Is that possible?
Well, I think there's a real mismatch between the fact that investment protection locks in certain investments, making it very difficult for states to make an energy transition at the speed required today, as Minister Claude Turmes mentioned, and the pledges made in the Green Deal very clearly. I think the dangers really are threefold in the treaty as it is. First of all, there is of course the danger that the investors in fossil energy production sue countries when countries decide to make an energy transition, like Germany was sued by the Swedish company Vattenfall in this most famous case following the choice to move away from nuclear power in Germany. And we have, of course, many examples showing how extremely costly this can be to states, because it's not only the sunk investments that are protected, it's also the future profit expectations of companies, so that they can sue states for amounts that are significantly higher than the investments they've already made. That's danger number one. Danger number two is the chilling effect on states who may fear to adopt certain regulations, to make certain changes, if they consider that there is a risk to their reputation if they are sued by an investor who feels that it is being cheated, that its profit expectations are being disappointed. And in fact, there are many more projects that are renounced by states than projects that are adopted by states that lead to litigation. And thirdly and finally, it's important to realize that in this area, quite a few energy projects have actually been privatized, and what was formerly managed by the state was made to be managed by private companies following a concession. But the re-municipalization, the retaking by public entities of that production of this service provision may also lead to litigation, as we've seen in a suit by the Czech company CAZ against Albania in 2013 for 190 million euros, because the Czech Republic was unhappy about the consequences of privatization. So there are huge risks associated with the ECT, and I think now is the time for the 26 member states who have not left the treaty, Italy being the exception, to leave en masse and to negotiate between them an agreement according to which their investors shall not be able to rely on the Energy Charter Treaty against other member states. I think that is the only way out, and it's the only way to ensure that the Green Deal can actually be fully implemented in the energy context.
Thank you, and thank you for explaining very clearly the costs of that ISDS mechanism. Aurore, let me come to you. You're one of more than 100 MEPs who is calling on the EU to withdraw from the ECT. I think if you asked the average person on the street that if they knew their tax payments were going to fund fossil fuel companies' profits, they would be horrified by this. Do you think there's widespread enough knowledge that this exists?
Hi everyone, I will switch to French. Thank you for the invitation. En fait, la réalité, c'est que c'est un traité qui était très, très peu connu, mais même des parlementaires. Et je profite de la plaisance de Claude pour le remercier infiniment, parce qu'il fait partie des politiques qui sont montées sur le sujet. Donc nous, au niveau du Parlement européen, effectivement, vous avez cité, Jennifer, l'appel qui a été fait par les 280 parlementaires pour demander qu'on commence tout de suite à réfléchir à une sortie coordonnée, parce que comme Olivier et comme Claude l'ont parfaitement dit, c'est un traité d'un autre temps. C'est un traité qui a été fait à un moment où notre peur, c'était quoi? Qu'il y ait un peak oil et qu'on ait un jour plus de pétrole. C'était ce moment-là, c'était le moment des conflits géopolitiques avec l'Irak, etc. Donc, on était totalement dans une autre perspective. C'est vraiment un traité d'un autre âge. Donc, effectivement, nous, tout de suite, on s'est dit, c'est super si on arrive à renégocier ce traité, à la fois sur l'ISDS et sur le fait de sortir de la protection des énergies fossiles. Mais comme on a très peu de temps, très peu de temps pour pouvoir réorienter notre modèle de production, d'échange et de consommation, il faut tout de suite aussi penser à une sortie coordonnée de ce traité. Donc, l'un des premiers job qu'on a eu à faire, c'était déjà de dire aux parlementaires, d'expliquer aux parlementaires qui eux-mêmes, souvent, ne connaissaient pas ce traité, tout simplement. Donc, ça a été ça. Et puis, de compter sur la force des ONG qui ont été remarquables, des think tanks, etc., pour pouvoir faire en sorte que, justement, au niveau du public, on commence à avoir un petit peu de pression, parce que ça marche comme ça, la politique. Hein. Il ne faut pas se mentir, il faut qu'il y ait un peu de rapport de force. Et dans ce cadre, effectivement, parler de ce traité, expliquer qu'aujourd'hui, l'argent dont on a cruellement besoin dans ce moment de crise de Covid et de transition écologique va vers le soutien des investissements qui nous font du mal, et qui vont vers le privé plutôt que vers l'intérêt général, oui, effectivement, c'est choquant, c'est impossible. Et c'est pour ça qu'on continue à se battre et à être extrêmement vigilant sur le sujet.
Merci, Aurore. Nathalie, give us your perspective on what is likely, what is possible during the current round of talks.
Yeah, thank you, Jennifer. And I think that Minister Turmes and others have really set the stage. And I want to kind of bring our discussion even into a little bit of a broader context first. So when the Energy Charter was adopted in 94, the issue of investment protection, the way we know it today, was pretty much unknown. And it was a different era, really. as we heard from others. And investment wasn't even taught at universities, and the focus was very much on international trade law. And so the energy or the sectoral energy protection regime that was set up under the Energy Charter Treaty went really unnoticed, even at the time. So we're hearing today, we don't know much about it. Well, at the time, there was no discussion about it when this was negotiated either. And this was a little bit like the simultaneous negotiation at the time of the investment chapter of the North American Free Trade Agreement. And that agreement between Canada, the US, and Mexico, by the way, was just recently replaced by a new agreement, which in large part eliminates investor-state dispute settlement, or for some areas curtails it very significantly. So today we're looking at 1,061 known investment cases under investor-state disputes, and under these various agreements. And 131 of them, or just over 12% of these disputes, were brought under the Energy Charter Treaty. And under the Energy Charter Treaty, we have seen the largest awards. The highest award ever handed down was under the Energy Charter Treaty, amounting to 50 billion, I'm repeating, 50 billion euros. And we also have an increasing number of challenges by investors against countries who are pursuing ambitious climate policies or other public policy objectives under this treaty. So all this is happening in a broader context. And this is not only about the Energy Charter Treaty, therefore, but also about the whole investment treaty regime. An investment treaty regime, as we know, consists of almost 3,000 bilateral agreements, as well as investment chapters in free trade agreements. And what's different about the Energy Charter Treaty is that it is sectoral. So it focuses exclusively on energy. It's also, unlike most bilateral treaties, multilateral. So we have several parties. And it includes strong economies that are simultaneously capital importers and capital exporters. And that's why so many cases are brought against industrialized rich economies under this agreement, unlike the bilateral treaties. But the problems that have come to light in the past few decades, as I said, concern the whole regime. And there's consensus that there are huge problems with these early generation treaties, both in terms of the law and in terms of the infamous investor-state dispute settlements system. And that's why the Energy Charter Treaty states started this modernization process. It's a very beautiful term. I haven't heard it used in other contexts. It sounds very promising, but unfortunately, not all states have the same view as to how much and what should be modernized. And so I assume we'll come back to all that in later discussions. So I'll stop here. Thanks.
Thank you very much, Nathalie. You mentioned there, this was sort of its time, of its era in the 1990s, but we saw ISDS raising its head not even that long ago with the TTIP arguments. I mean, are there debates that happened around that could be brought to the ECT, just as a follow-up?
Absolutely. Every concern that has arisen under any treaty, under any negotiation to date, is applicable also for the Energy Charter Treaty. It's no different. The difference is that it's focused on one sector. So in fact, we shouldn't even forget all those other treaties, because they also apply to the energy sector. But yeah, definitely the discussions are relevant for the ECT discussion as well.
Okay, Claude, let me come back to you and ask, what do you think would be the minimum requirements of the reform for it to be called a success?
I think the absolute minimum is to get rid of fossil, or at least most of the fossil, and I think we will probably discuss later the EU submission for what is called the economic chapter, which is of course a compromise between people like me and people like those from Visegrad. And I think it's a compromise which is much closer to the progressives in Europe than to the Visegrad countries. So I think that's the least. And then of course, arbitration is something which at least needs boundaries. So if you still allow for arbitration, then it cannot be this open-end profits forever. And then private lawyers with multiple strange interests. So I think these two things will have to change.
Olivier, same question to you then. What would you see as a potential success for the modernization?
Well, I think one major difficulty you see is that in other areas, states in investor-state dispute settlement proceedings can invoke certain other international agreements to say, we are acting in the public interest, and the restriction we're imposing on investors' profit expectations are justified by the public interest objective we are pursuing and the treaties we have also to comply with, for example, human rights treaties. But the Paris Agreement, unfortunately, is not going to be easy to invoke against the big players from the fossil energy industry who complain that their investment is lost and that their profit expectations are disappointed. And the reason is that the Paris Agreement is not clarifying the speed at which each individual country should move. This depends on the intended nationally determined contribution of each to the overall objective of not driving the planet into a danger zone. And so I'm very skeptic that the Energy Charter Treaty can be rescued at all. I would suggest that we do not need it. The most extreme violations of the rights of investors following, for example, a nationalization process of the assets can be protected by other means. General international law is there for that. And this treaty should be left aside and abandoned. And at the very least, the ISDS chapter, the chapter on investor-state dispute settlement, should be either removed or then entirely rethought in order to have investors claim, if any, compensation before domestic courts, but clarifying that the states bound by the treaty should have the right to legislate in order to effectuate the energy transition and to comply with their commitments under the Paris Agreement. Without this, which we will not be able to obtain from the 57 states parties, without this, I think ECT is simply not something that we can rescue at all.
Thank you. I'm going to come back to Alexandra in a moment, but Aurore, what is your thoughts? I mean, do you agree with Olivier? Is it not fixable?
La difficulté, c'est que c'est très dur de négocier avec la nature. On ne négocie pas avec les limites de la planète, tout simplement. Donc, il va falloir à un moment faire des choix. Et alors, effectivement, dans les lignes rouges, je vais rejoindre ce qu'ont pu dire Claude et Olivier, c'est-à-dire qu'il nous faut la fin de l'ISDS, il nous faut la fin de la protection des énergies fossiles, il nous faut la fin des cas intra-Union européenne, qu'on cesse de s'attaquer les uns les autres. Enfin, je veux dire, c'est absurde au bout d'un moment quand même, qu'on fasse montre de solidarité dans ce moment particulièrement difficile et pour mettre en place le Green Deal, et puis mettre fin aussi à la Sunset Clause. Et quand j'ai fait la liste de tout ça, force est de constater que malheureusement, ça veut dire globalement la fin, à mon sens, vraiment de ce traité. Alors, si on arrive à supprimer tout ça, tant mieux, je m'en félicite. Mais c'est quand même malheureusement le cœur de ce traité. Mais moi, ce serait ça, mes lignes rouges, encore une fois, parce qu'effectivement, au niveau européen, on est dans un esprit de compromis, mais on est aussi dans un esprit de rapport de force vis-à-vis des autres pays qui sont dans ce traité. Il ne faut pas l'oublier, il y a d'autres pays. Donc, il faut un moment que l'Europe montre aussi qu'elle sait défendre ses intérêts, qu'elle sait défendre les Européens et qu'elle ait des lignes rouges extrêmement fortes.
Thank you. Alexandra, you heard there from Aurore saying there must be sort of red lines defending Europeans, but also Olivier pointing out that there may perhaps be a mismatch, if you like, between the ECT and the Paris Agreement. Is that the thinking in the Commission? Is there a tension between which particular treaty to follow?
Well, let me maybe start by also stepping back on the fossil fuels, because I think the situation here also has changed dramatically over the past 10 years. 10 years ago, coal was probably the cheapest option for producing electricity in most places in the world, also including a lot of EU member states. 10 years later, with the huge decline in the costs of renewable energy technologies, we are already in a very different space. And this is, I think, important when we consider the future claims of companies. It's not only about policy, it's also about markets that are driving this change. Now, when it comes to the modernization of the ECT, we are coming to these negotiations in good faith. We committed and we got the mandate from the member states to modernize the Energy Charter Treaty. We made proposals which essentially exclude fossil fuels from the scope of protection of the Energy Charter Treaty. We consider this an ambitious proposal. And we are pushing hard, and we will push hard to get a successful outcome on this front. It's not going to be easy because there are more than 50 parties to these negotiations. So clearly this is not without challenges, a lot of them with very different interests and starting points. Well, different starting points is something that we know in the EU, but perhaps at a scale which is slightly different. But to be clear, yes, we come to this process in good faith. We said we would attempt to modernize. This is what we're going to do. But we also said that if we are not successful, we will examine all the options, and that will also include withdrawal. One of the reasons why we want to modernize first and put all of our energies into trying to modernize and convince our partners that they should be doing the same is also because we believe that we can get a better outcome if we manage to modernize the Energy Charter Treaty. There is the sunset clause that was already mentioned, the 20 years. Well, one of our member states has left the treaty. This is the sunset clause that is applying. So we have to be very resolute. I totally agree with the speakers that come before. And when we realize that this is really not working, we have to look at all the options. But there would be no point engaging in negotiations, knowing already that this is something that we totally don't believe in. That would not be coming to this negotiation table in good faith.
I take your point there, and you're saying that the proposal is ambitious. I mean, others might say it could be more ambitious. I mean, what is the red line? I mean, is walking away if you don't even achieve the aims of the proposal on the table?
Well, so what we proposed is to exclude fossil fuels from the scope of coverage of the Energy Charter Treaty. That is, let's say, the general approach. That would mean that once we manage to modernize the treaty, new investments in fossil fuels would not be covered, apart from exceptional areas such as in gas-fired power generation. But even there, according to a certain threshold, we proposed a threshold of 380 grams. We proposed also a limited time frame for this, 10 years. So it is already, I would say, quite well defined what the exceptions would mean. And of course, for the existing investments here, we have also proposed to remove those from the scope of coverage of the Energy Charter Treaty. So that would mean that essentially once we manage to modernize the treaty, within 10 years, the treaty wouldn't be covering any fossil fuel investments anymore. In comparison to the possibility of having the sunset clause applied, this would clearly be a better outcome if we manage to do this. And that's what we would consider a success.
Okay, I mean, 10 years is the time frame you're talking there. Nathalie, let me turn to you. Do you think the proposal from the Commission is ambitious enough?
Well, I guess before answering that question, I'd like to kind of take a step back. So we have a group of countries and they're negotiating on basically investment in the energy sector. And, you know, they should be discussing what is the role, what do we want to achieve with this, this outfit that we have, this platform we have. Well, I think that they should be negotiating, you know, how to accelerate and support the clean energy transition, achieve the Paris goals. They should be thinking about phasing out certain kinds of investments. We're talking about phasing out what? We're talking about phasing out the application of something harmful, but in terms of ISDS. But that shouldn't be the topic. It should be about actually phasing out and committing together to phasing out certain types of activities to support the Paris Agreement. You know, you could be thinking about, how do I achieve this objective? How can I stimulate finance into these areas? How can I support, how can I as a home state support the positive kind of investment? But there's no discussion about that. This whole negotiation is about damage control. It's about trying to fix something. And so before even going into these negotiations, the parties already put themselves into handcuffs. They can't really negotiate what's really important. They're only talking about how to limit the harm. And that's okay. We have to do that for sure. But because of that, you know, looking at what the EU is trying to do, well, compared to the other parties, for sure, they're trying to limit the harm more effectively than some of the other parties who really don't want to change anything. But at the same time, you know, the EU, of course, we heard already from other speakers, and then even in this prep session, the EU's general rule, so they're trying to do something about the substantive elements of the treaty to avoid the worst type of interpretations by tribunals, okay? They're having some resistance. Then they would like to see an investment court or investment court system to move away from this arbitration circus, but they can't talk about that in this negotiation because it's not on the table. And then the last is to try to limit the scope of application of this new deal, and to say, well, for existing fossil fuel investments, we're going to only, you know, we're only going to benefit from these extraordinary investor state rights for another 10 years after the amended treaty enters into force. So you still get that protection. So there's still a problem there. And there's some more immediate harm, let's say, reduction for new investments, but we've seen there, we can have a discussion about those exceptions to that rule for new investments. But for old investments, we have another 10 years of investor state dispute settlement, even though we know we have to, you know, we have to do something today. We can't wait for 10 years. So yeah, sorry, but I think that in principle, if we really wanted to have a good outcome, the parties should have scrapped the agreement and started from scratch to say, how can we really support the Paris commitments through our platform, through our actions through the ECT.
Claude, I think you wanted to react to some of what you've heard already. Is that correct?
Yes, so I cannot speak for the others, but I can speak for myself. So I want renewable investments to speed up and to be much bigger in volume. I want energy efficiency investments to speed up and to be much bigger in volume. And that is part of the actual text, but there is also new text, especially on energy efficiency equipment, in the new proposal of Commission. So it's not true that it's so of course, the tip of the iceberg is phasing out fossil fuel. But there is new wording proposed by the EU to enhance for example, the energy efficiency investments, and to create also, in a certain sense, a favorable investment climate for green hydrogen. So hydrogen is, I'm not at all in a hydrogen hype. So it is, I would say, a maximum of 5–10% of the story of decarbonization. The rest is direct electrification, because that's much more efficient. But we will need some renewable produced hydrogen, and some of that will be produced globally at places where you have better renewable conditions than we have in Europe. So I think that is part also of the story. And on the sunset clause, and maybe Alexandra can also come in on that. My understanding is that all protection of coal and oil is gone under the EU Commission's proposal. The only thing which is protected for another 10 years is gas power plants with what we call an environmental performance standard of a maximum of 380. The proposal of Commission is de facto erasing the sunset clause for all fossil fuel but those gas turbines. Good, and then we can have a whole afternoon discussion. Can we speed up renewables without that in the next 10 years or not? But I think it's really, so it's an almost complete ban of fossil in the EU proposal. And that's also the reason why I support it largely.
But before I go to Alexander, we have a question in from a member of the audience, Francisco Padilla Olivares. Asks, you mentioned your position, Claude, but asked, what is the Luxembourgish government position with regard to the withdrawal option, and when should that be explicitly on the table?
My position is the government's position. So I put the things on the table. This is I'm doing that in agreement of my government, and of course, if there is no movement, then we will have to withdraw. But when you start negotiations, especially in a global context, if I come to you and I say to you, look, let's negotiate, but I tell you already, I will go out, then I think there is no negotiations. So I think we must be clear, what do we want as European Union? That took us more than a year, and I was not happy at all with European Commission because it took so long. But now finally we have a position, and that's a position which is, I think, a compromise, but which is much more to the progressives. Just invite the Polish energy minister or the Czech one to your next roundtable, and you ask him if he's happy with the EU compromise text. I will be curious what he will say. Huh?
I think you know what he will say. But let me push you a little bit more on this, because there are deadlines involved, and I think it was you said that March is our last chance for a deal, but we're at the end of March today. I mean, how much longer do we keep feeding out this mope, and does there come a point where enough is enough?
So of course this is negotiations behind closed doors, so you will understand that I will not give you all kinds of details. So the official round didn't move anything, but there was a workshop dedicated only to the question of phasing out of fossil fuel mid-March. And now at least, I think, and that may be the last opportunity in a certain sense, the next official round is in June. And in June, I think there is no excuse anymore for the UK government, which has a net zero commitment, the Swiss government, which has, and maybe you all try to organize a roundtable in Switzerland, because Switzerland has a bit of puzzling, not very understandable position, the Norwegian government. And then of course the Japanese government. So that's the four governments which in a certain sense, we need to understand what is their position. I think if we take the EU as basically, and for me, it's a bit of a minimum where we can go if we want to be consistent with climate policy and also improving the arbitration, at least to a certain level. So it's these four countries which now to come out of what do we call this? Come out of the forest, or basically be clear. Well, what is their position? What is the British government's position? Is it really we don't want to change a iota? Good, but then how is that compatible with being the organizer of Glasgow and wanting to be the savior of the planet? So I think there is a much bigger contradiction on that government side than on the EU negotiation side for the moment.
Olivier, you wanted to add something?
No, I'm delighted to hear that there's these discussions going on with these states that Claude Turmes just mentioned. I do think it will be extremely difficult to reform the treaty, and however ambitious the modernization proposals are that the EU has put on the table, I think the credibility of those proposals will depend on the EU saying very clearly that if those minimum requirements are not met, we will move out. And without that threat being very explicitly formulated, I think the EU will be just not in a position to make a difference. However, we should realize that the ECT, without the EU 26 member states, again, Italy being already out, will not make much sense anymore. And so the EU has a negotiating position that is stronger than the compromise approach it is now pursuing seems to suggest. And it should be very clear that if those minimum requirements are not set, it should simply threaten to move out from the treaty.
Alexandra.
Yeah, that's a question to Alexandra also.
Alexandra, your floor is yours to respond.
Yeah, well, I think I already revealed what our position on this was. If we consider we're not successful with the modernization, we will consider all the options, and clearly withdrawal is one of the key options here. So there is, I think, absolutely no doubt what our position on this is. You know, whether the negotiations are going fast or not fast. Just to put everyone on the same page, because I think most of this is public information. Last year we had 3 rounds of negotiations. This year we have 4 rounds of negotiations. One was in March. We are pushing to have this discussed in June as well. This is not yet, let's say, guaranteed, but we are, of course, adamant that this should be discussed in June as well. There was the informal meeting. We are trying to get some of the parties out of the woods, as Claude said, or forest, I guess, depends on the geography.
Woods is better.
Woods is better. So outreach to other signatories, parties to this treaty is very much a priority right now. Some of them have already been identified as part of this discussion. So yeah, very much doing everything we can, pushing for the modernization. And this year, that's why we have the 4 rounds of the negotiations, to give ourselves as much chances as possible to actually make it happen. But I also wanted to make one comment. I would maybe, I think it would be maybe not exactly fair if we judge the whole discussion on energy transition just through the prism of what is happening on ECT. It's a little bit like a 3-dimensional cube. You can look at it from one side and think, well, this is perhaps not ambitious enough. But alongside this, when it comes to substance of phasing out fossil fuels, we are working really hard on these elements as well. First of all, coal phase out is already happening in the EU. We have tools to support that, the Just Transition Fund, the Just Transition Mechanism, a number of other funds. We are proposing the Fit for 55 package in June, which is going to strengthen the carbon price. So all of these elements are going to necessarily align the energy transition with the European Green Deal. So we shouldn't put all of the expectations on the Energy Charter Treaty. This is not an instrument that is going to deliver energy transition, but it's an instrument that we want to support energy transition. So I would just be a little bit cautious with forgetting that there are all these other very important policies that we're putting in place, which will guide the energy sector where it needs to be in the future.
Fair enough. We're not really talking about those today, but I mean, it's a question that's been raised by our audience about the need for unanimity to achieve reform. And we've already heard, I mean, Claude mentioned specific countries. We also know that Japan does not want to include any new items for negotiation. So would the EU agree to a so-called modernized ECT, even if it included some of these outdated ISDS mechanisms? And really, what is the deadline for making a call on that, Alexandra?
Well, I'm not going, sorry, I had some water and my voice is gone. I wouldn't like to comment on any theoretical scenarios of where we could get, because we still don't even know where these negotiations are going to take us. So this is, I don't think we're in a position to comment on possible outcomes and then how we would position ourselves. I think we will take the decisions on the text as it evolves. But for now, I think our position is very clear. What we consider is a Paris-aligned and Green Deal-aligned outcome of this modernization process.
Aurore, you're keen to comment.
Oui, juste pour dire plusieurs choses. Tout d'abord, il faut rappeler qu'il y a aussi la France qui a une position relativement ferme maintenant, désormais, sur ce traité, et aussi l'Espagne. Et que l'Espagne a été plus ou moins claire sur ce sujet-là en disant, attention, nous, si on a un accord qui ne nous convient pas, on risque d'en sortir de manière unilatérale, un petit peu comme l'Italie, parce que c'est un pays qui est extrêmement attaqué, pour le coup l'Espagne. Ensuite, moi, j'ai un souci quand même de cohérence en termes des politiques économiques et en termes des politiques environnementales. C'est-à-dire que 10 ans, on a quand même un problème d'actifs échoués à gérer. Hein. Et sur la question des actifs échoués, on est à minima sur du 2000 milliards d'euros. Donc, en gros, est-ce qu'on se dit qu'il nous faut, j'entends bien et vraiment, j'en comprends la problématique d'Alexandra de dire qu'on arrive à la table des négociations, c'est pour négocier, bien sûr, évidemment, mais à un moment, je suis absolument navrée, mais si on se dit qu'on doit respecter l'accord de Paris, qu'on doit respecter le Green Deal, qu'on a 10 ans pour tout changer, qu'on a relativement peu d'argent, etc., quand on met tout ça, qu'on voit que la Banque Centrale Européenne, elle aussi, par cohérence, est en train de réfléchir à changer sa politique pour avoir une politique micro-prudentielle qui permet d'aller vers plus de vert, à la fin des fins, la conclusion, elle est quand même relativement sans appel, me semble-t-il. Et je comprends l'idée de partir de l'existant et d'essayer de l'amener vers le meilleur, mais l'existant, ce sont des textes écrits par des êtres humains, avec des contraintes économiques, j'entends bien, mais l'existant aussi, ce sont les limites de la biosphère. Et j'insiste encore une fois, elles ne sont pas négociables. Et on a besoin de chaque euro pour pouvoir, non pas sauver la planète, parce qu'elle ira très bien, elle nous survivra, peu importe son état, mais nous vivre correctement en tant qu'être humain, tout simplement. Donc, la question, la bonne nouvelle aujourd'hui, c'est qu'il y a une prise de conscience, il y a un vrai moment de négociation, etc. La mauvaise nouvelle, c'est la question du timing. Et le timing dans la transition écologique, il est essentiel, en fait. On peut pas faire de l'à peu près. Ça nécessite un timing serré et une vraie cohérence des politiques économiques, j'insiste. Même si je comprends vraiment la situation dans laquelle se retrouve la Commission et Alexandra notamment.
Alexandra, do you want to respond?
Yeah, well, I can only agree with what Aurore said. The reason why we presented the European Green Deal is that we strongly believe that we cannot and we should not, and we don't want to negotiate with nature. So the pressure of time is definitely there, and we will be and we are looking. Well, maybe not day by day, but round after round, exactly what is happening, and we are very much aware of the pressure of time. But I also am aware of the sunset clause, and I think it would be a worse outcome for the economy and for the energy transition in Europe if we had to be stuck with investment protection for the most polluting fossil fuel infrastructure for another 20 years. So that is why before we activate any other plans, we want to try to get the best outcome out of these negotiations.
Thank you. Nathalie, I'm going to ask you a question that's been put by an audience member. Ricardo Negro asks, what about the ruling of the ECTJ that would declare the ECT not applicable in the EU? Would it terminate it once and for all, including making the sunset clause non-applicable?
I think maybe in the round you have more EU specialists. I'm more of an investment lawyer, but I can say maybe two things in this respect. First of all, I do think that the most secure, obviously, if there is an amendment, there is no indication that that amendment would result in something that's conform with what we have in terms of ACMEA and other decisions and opinions that have come out most recently. So it would simply mean that we would have a new treaty or an amended treaty, and the problem wouldn't be resolved. And so I guess the bottom line is, the fact that there's no coherence or no compatibility with EU law doesn't automatically mean, or not at least for the tribunals, mean that they cannot apply the ECT, despite the fact that EU member states are saying that this is not compatible with EU law. And so there is another action needed. Either they have to do it, the parties have to address this issue head on in the amendment, which is unlikely. But they would have to say that the ECT is not applicable between the member states. That would be one thing. And I think that Olivier already mentioned that. The other option, of course, is to withdraw from the ECT. And if there are concerns about the survival clause, that there should be an agreement amongst the members at the same time of withdrawal between the EU member states to neutralize the survival clause amongst themselves. And of course, that way, the risk between the members would be greatly reduced. You would still have the risk under the survival clause between EU member states and non-EU member states. But as we have seen, that many of the actual cases were brought between member states. So the risk would be greatly reduced. Of course, it's never 100% bulletproof. Nothing in international investment law is bulletproof, because tribunals do kind of have created their own kingdom and will do a little bit what they want. But it would be more expensive and more risky, and even very risky for investors to bring claims if member states withdraw plus neutralize the survival clause amongst themselves.
Olivier, your thoughts on this same issue?
Yeah, well, I share this view that Nathalie expressed, but I would be much more radical. In fact, my reading of the Achmea judgment of 6th of March 2018, which concerned the 1991 bilateral investment treaty between the Netherlands and the Czech and Slovak Federative Republic, my reading is that this makes it illegal under EU law for one investor from one EU member state to sue another member state before an arbitral tribunal. So what do we do with this judgment? Is a question I would like to ask Alexandra Tomczak. My own view is that the principle of sincere cooperation, which the court cites in the Achmea judgment, requires from the EU member states that they negotiate between themselves, confirming what is the requirement of EU law, that they will not allow their companies to sue another member state to complain that there is a violation of their investors' rights, and that that kind of dispute should simply be before the domestic courts using the classic right to property protected under international law, without any additional protection, referring, for example, to the fair and equitable treatment referred to in Article 10 of the of the Energy Charter Treaty. So my view is that the EU member states should comply with that judgment that, in my view, makes it illegal to invoke the ECT for European companies suing an EU member state. But the EU member states should act consistently with this requirement.
Alexandra, is that your interpretation as well? And how do we get around that seemingly contradictory positions?
Yeah, well, I think Olivier knows also about the judgment that we are waiting for right now in the case of preliminary reference case pending before the ECJ, and there was a request for an opinion by a court in Belgium on the applicability of the ECT in intra-EU cases. And here clearly this is a judgment that we trust could really clarify the issue of applicability of the ECT in intra-EU cases. And this is a judgment that we are waiting for right now.
Okay, well, let's move on to the possibility of a withdrawal, assuming negotiations don't go as people want them to. How, when, and how should that be done? We've already seen countries like France and Spain calling for this withdrawal. Claude, what's your position on an organized withdrawal? What would that look like?
I think an organized withdrawal is, in a certain sense, in the air. Also because of this court case, which will be decided on soon, that within EU countries there will be no arbitration anymore. So I think I have read also what the Attorney General says. Good, and that looks really that this Achmea and then afterwards now this more recent case that is solved. And then I think what we have to do also within now EU and together with Commission and I think also with the expertise of you is if EU countries go out, and I think this has been mentioned before, there is still a possibility for an EU company to go to Switzerland and to attack an EU country. There is an Azerbaijan company so all those who are member and who are not EU 26 can still file. So I think we need to get to better understand how many potential cases are there. Is it true that if EU withdraws from arbitration, that the arbitration, that the likelihood for such a case is changing? So I think that's one aspect which we really have to better understand. And then there is a second issue, and I think Olivier mentioned it before. is it, and that's also a question which we have to think about, is the ECT dead if EU countries move out? At first look or glimpse, yes, but imagine, I don't know, Japan and China. So if EU is out, of course, the rest of the people who are in are free, for example, to invite China to be a member of that treaty. And for example, next stage could be we go to Africa. So I think there is these two questions, I think is what we have to understand now. I think EU internal arbitration, this is solved. The court has solved this for us. And we were, I think, already anyway on that way. Now the question is, if EU countries don't fight each other with arbitration, how big is the risk for others to fight us? And then the question, is this organization really dead if EU moves out? And I think that's the two questions, the only two questions which I think could prevent EU not to withdraw. If we would come to an answer which is we would say, okay, that risk is a big risk, but for the rest, I think things are now clear.
It doesn't sound like you really think it's dead or that withdrawal is really an option. It seems a little bit like hedging bets there.
No, not at all. But I think we are in a global. It's not about only about Europe. Of course, most cases were in Europe, but most cases were also in renewables. I think that's not very well known, but a lot of cases are against the former Aznar right-wing conservatives anti-renewable policy. Good. Now you can say, is arbitration the right way? But it was so evident that all these investors at that time were not allowed to go to the Spanish court. So I think also on that, things are not completely black and white.
Well, I mean, one of the reasons I say this is because Guy Lens is being sent as a possible next Secretary General. I mean, that doesn't speak of a country that's keen to get out of the ECT.
Look, you think whatever you think, but if you believe that my political position is bound by this kind of product placement or person placement, okay, it's your right to think about this. Good, but I have my opinion. Good, and I have, I think, also my credits. Hopefully, over the last years. So if you really think that is, of course, you can say, was it a wise move? Good, and we are now. People think that I'm almost corrupted by this. Good, I have to accept it. But look. Don't be sure that is my driver.
Okay. Aurore, let me ask you then the first question there, which was, what does a organized withdrawal look like? I mean, and how does that happen in a timely way? I mean, there's been a lot of deadlines thrown around during our discussion today. You know, some deadlines have already passed. Some are saying, oh, we keep negotiating for another year, then perhaps Glasgow is another deadline. At what point does the conversation come around to we need to withdraw and how to withdraw?
C'est vraiment toute la difficulté. C'est-à-dire que nous, on s'était dit avec beaucoup de parlementaires, on va attendre jusqu'à la fin 2020 et puis si rien ne se passe, voilà, il faudra préparer 2021. Moi, ma crainte, c'est qu'on s'enlise justement dans des négociations interminables parce que tous doivent décider à l'unanimité. Et en fait, c'est là la grosse difficulté de ce traité. C'est que pour pouvoir le réformer de manière ambitieuse, si c'est possible, il faut l'unanimité. Pour pouvoir en sortir, il faut l'unanimité. Donc, on est quand même dans une situation très, très, très compliquée. Et en fait, j'entends parfaitement la crainte de la sunset clause, etc. Oui, mais à partir du moment où on sait en fait qu'on ne va pas forcément réussir à le renégocier, à la rigueur, autant peut-être en sortir tout de suite. Et comme ça, la sunset clause commence tout de suite finalement et on n'a pas à attendre 1 an, 2 ans qu'elle se déclenche. Donc moi qui ne suis pas du même parti politique que le gouvernement français, j'approuve pour le coup la lettre qui a été écrite par le ministre de l'économie français et le ministre des Affaires européennes quand il demande pour le coup une évaluation publique et expertisée des modalités institutionnelles et budgétaires d'une sortie concertée. En fait, je pense que c'est vraiment là-dessus qu'on doit maintenant travailler. Par ailleurs, je trouve qu'on a toujours tendance à sous-estimer notre rapport de force côté européen. Vraiment. Je ne sais pas si on a un complexe d'infériorité ou quoi, mais l'Union européenne, c'est quand même un acteur économique et politique majeur. On a du poids dans les négociations. Et petit rappel, 65% du secrétariat du TCE est financé par l'Union européenne. Donc, je veux dire, il y a un moment, on a du rapport de force. La question est de savoir, est-ce qu'on compte l'utiliser entre nous et à se faire la guerre? Ou est-ce qu'à un moment, on estime qu'il faut l'utiliser vers l'extérieur et dire, bah non, en fait, ce traité ne nous convient plus et on ne va pas forcément être des bons élèves. On va faire du rapport de force, on va négocier parce qu'on a 10 ans pour tout changer.
Mais bien sûr, but what is the position of the European Parliament? Can the Parliament set a deadline?
Alors, on n'a pas fixé de deadline. Par contre, on serait ravis d'entendre pour le coup ce qu'est une deadline raisonnable selon la Commission européenne, parce qu'on trouve que c'est un petit peu flou. Non, ce qu'on a dit par contre immédiatement, c'est de dire il faut commencer. Enfin, on a demandé à ce que dans des amendements dans la loi climat notamment, que soit retirée les énergies fossiles de la protection. Et après, on est 280 parlementaires à avoir demandé à une étude immédiate et une réflexion immédiate d'une sortie concertée de ce traité qui, moi, franchement, quand je vois la situation, à titre personnel, me paraît quasi inéluctable.
Alexandra, what sort of steps is the Commission empowered to take at this point to start looking at the possibility of a withdrawal and organising to do that?
Well, first of all, I agree with Aurore on the leverage that the EU has in international negotiations. And I think also if you look at the fact that only over a year ago, we were the only ones to commit to climate neutrality. And today we have also Japan, South Korea, and South Africa, and a number of China carbon neutrality as well. I think you can clearly see that we are not shying away of playing this leadership role when it comes to climate negotiations. And this is what we would like to put in practice when modernizing the Energy Charter Treaty, because of course we realize that we are a major player in this treaty and also in the negotiations. Yes, I think there are two ways of looking at it. How do you use your leverage? And if you use it in order to reform the institutions that you are part of, well, this is the option that we are focusing on right now. Otherwise, I think we have enough rounds of negotiations scheduled for this year to have a really good overview of what the situation is and how far we can go. I wouldn't like to go into presenting the legal details of what the withdrawal would entail and how it would work, first of all, because I'm not a lawyer. And secondly, because I think there are a number of lawyers in this meeting who probably are well positioned to discuss this in more details.
Well, I mean, you talk about leverage. I mean, leverage is only as good as your negotiating counterpart thinks you are serious. I mean, if there's no plan to walk away, doesn't that undermine the position of negotiating?
Well, I think also you can look at it in two ways. If your negotiating partner knows that you're not coming to the negotiations and discussions in good faith, I'm not really sure how far that sort of approach can take you. So there are two ways of looking at it. I'm pretty sure, at least I hope, that some of our partners are closely following also our internal discussions like this one in the EU, that there is a lot of pressure to take certain directions, that the European Parliament is heavily involved. I would also guess that our partners are aware of the political circumstances in which we are operating, and including the quite strong position of the Parliament on this. So again, I think we are being honest in this discussion. There's you know, a very clear commitment to reform in good faith, but I think also very clear that that there is a lot of pressure on the EU to be very strict in these discussions.
Olivier, what's your position with regard to withdrawal?
Well, I think having a plan B, if the proposals on the table are not achieving consensus, a plan B being withdrawal, would strengthen the negotiating position of the EU. And I also think that we have with this ECT a very unsatisfactory situation that cannot last infinitely or eternally. And it is true that the sunset clause is a real problem, because it means that as Italy has experienced, it's not because you withdraw that you cannot be sued for 20 years following the date of the withdrawal. But if the EU decided to raise that possibility, it would certainly make it easier to convince the other parties to take seriously its proposals. And frankly, if the EU leaves the treaty because it feels that it is not consistent with its agenda for change, the interests of other parties will be very limited in maintaining the treaty as it is, given the weight of the EU in the whole system. So I think, as Aurore Lalucq has said, I think the EU should now play politics. You know, it should stop pretending that everyone is committed as it is, as the EU member states are, to the energy transition, and it should play on the possibilities it has to obtain the best deal possible. And I think it will only be credible if it prepares this scenario of withdrawal. And so for these reasons, I agree that that should be explored as an option in order to make that as realistic as possible.
And what are the consequences of remaining in the ECT? I mean, are we looking at the downsides of that? We're all speaking rather optimistically about modernization, but what if that doesn't happen? And then there is also no withdrawal. I mean, is this...
Well, look, very simply, every time an EU member state will be thinking of adopting a regulation that will reduce the profit expectations of the oil and gas companies, that member state will think twice, because that state has reasons to fear that it will be sued for very large sums of money if a company considers that its profit expectations are disappointed. This is, for example, what France experienced when it decided that it would suspend extraction of fossil fuel from the French territory by 2040. The Canadian company, Vermilion, threatened to sue France, and as a result, France had to re-examine its legislation and decided that, of course, new extraction would not be allowed, but the renewal of existing extraction permits would be allowed even beyond 2040. So this is just one of dozens of examples which are not very visible. They're often below the radar of countries having renounced accelerating the energy transition because of the fear that they would be sued for large amounts of money. That is simply not acceptable. And beyond the dozens of cases that have been presented to arbitral tribunals for resolution, There are many cases that never went to an arbitral tribunal because they were negotiated behind closed doors and companies obtained, in many cases, what they wanted, in other terms, watered down environmental legislation. That is not acceptable. We have no time to lose, and we should now immediately draw the consequences from the fact that this ECT is delaying vital change that is essential for respecting our commitments to climate change mitigation.
Thank you. Nathalie, I'm going to ask a question. Ana Moreno has asked, made the point that the EU is considering promoting the expansion of the ECT to Africa. I mean, how does that square with the idea that some states want to withdraw while at the same time suggesting expanding it?
Yeah, this trend or this initiative within the Energy Charter Treaty Secretariat started some time ago, some years ago, when many even developing country governments were already undertaking a reform process of their investment treaties. The problem was that when the Energy Charter Secretariat reached out to these countries, they reached out to the energy ministries, who were very unaware of what the trade and investment ministries and agencies were already doing to reform investment treaties. And therefore, they were very unaware that this Energy Charter Treaty was actually one of those models that were no longer being accepted by their government, but there was not a real understanding about the potential consequences. So I'm not entirely sure, to tell you the truth, whether these this initiative has been put on hold or not. Certainly it should be, as the modernization process is taking place. It's quite a problem, but I don't know exactly where the Energy Charter Secretariat stands just now.
Okay, Claude, let me ask another question that's been coming in from our audience as well. The question here is whether the EU is a member itself, just as the states. What would happen if the EU exited the treaty, but states remained in? What would you see as a potential in that scenario? Thomas Brunner asked that question.
Good question.
Okay, that's your answer.
No, it's one of the nightmare questions or the nightmare outcomes. If some of the less progressive EU would see an interest to stay in. We are trying that was also a bit of a, educational is not a good thing, but some of our Eastern European, Central and Eastern European colleagues thought that they would not be touched by this. And I think we tried to say to them, look, you have more coal and gas than we have in Western Europe, so you will pay the price. If it is not today, then tomorrow. So, but this is a question which is a difficult question. So I hope and look, if it took a year to get us to the position, it was because inside Commission there was a lot of infights. And because it was not so easy to get all EU countries on the same hymn sheet. So good. But let's not talk too much about this option.
Well, I'm going to talk about it. I'm going to ask Alexandra about it. What's the take on that? I mean, Jean-Pierre Ernotte also asked, what if a couple of EU member states don't want to withdraw, but that the EU as a body does?
Well, yeah, I think I said it at the early beginning that it's not really my role to discuss the theoretical scenarios, but if there is no success in modernizing the Energy Charter Treaty, I think as Claude said, I don't really see why any country would have an interest in staying in, especially the ones that have a lot of investments in fossil fuels. But on the other hand, I think we should also keep in mind when thinking about accelerating the phase out of fossil fuels, I think what we see, at least right now, following the pandemic, is an acceleration of the phase out of fossil fuels. We only have 3 member states that have not yet committed to phasing out coal. This number has increased over the past 2 years. If anything, it looks like the energy transition is really accelerating. And I think the reason for this is, again, if we look at it as a 3-dimensional cube, not looking just from the regulatory and ECT perspective, but also looking at the markets. And we've seen recent reports by the Rocky Mountain Institute that around 80% of coal-fired power plants in Europe could be running at a loss. I mean, all these things add up to an accelerated exit from fossil fuels. And yes, policies and regulations are part of the facilitation of energy transition, but there is also the market development, the technology development that is also playing a role. So I would take a little bit of a broader perspective on this.
Well, all that being said, then, a sort of a final question really is, I mean, do we need the ECT? And if so, what do we need it for, Alexandra?
I think we discussed this also at the beginning, that the ECT is an investment protection tool. It protects not only fossil fuels, it also protects investments in renewable energy technologies. We are also proposing to expand the scope to green hydrogen, to other elements. And I think it would be in everyone's interest to see these investments being protected, in creating a business environment where investors feel like also investing not only in Europe, but also outside of Europe, in these 20 plus parties that we have in the ECT. Also, the clean energy transition has to happen there, and I think it's in everyone's interest to create an environment where investors are willing to put the money in the clean energy transition.
Okay, Olivier, your thoughts on, do we actually still need the ECT?
I think the ECT is an instrument from the past, and that the protection of investment should be much better aligned with other objectives that states legitimately may seek to pursue, including environmental objectives, but also the protection of local communities, very often very heavily affected in their human rights by extractive industries projects. And we should recall that in all countries, there's a minimum level of protection for investors that can be found in general international law. What such treaties add is a heightened level of protection under the vague wording of fair and equitable treatment for the investor that goes beyond the minimum right to be protected from expropriation or to be compensated for this. And it provides investors with access to arbitral tribunals established under, in general, the International Convention on the Settlement of Investment Disputes in Washington under the World Bank's auspices. So a sort of privilege to have access to these arbitral jurisdictions rather than to have to claim compensation before domestic courts. So I think if we did not have the ECT, we would still have a level of protection of investments that would be sufficient to protect investors from the most egregious cases of expropriation of assets, nationalization. And I think it is very problematic that we remain stuck in a treaty that has its origins in a very different time era, when the question of climate change mitigation was not at all the priority it has become since. So we can do without the ECT, and for the moment, I believe very strongly it brings about much more ills than it brings about benefits.
Well, that sort of feeds into one question from Frick Bersch in our audience, who is asking, has the existence of the ECT influenced EU climate policy so far? Has it perhaps lowered ambition? What would you say to that, Olivier?
Well, I think certainly it will be interesting to look at all the regulations that member states have renounced to adopt, have decided not to adopt finally, because of the fear of litigation if that regulatory change meant a loss of profit for the energy companies concerned. I do not know of any study being made, but it's important to realize again that the cases we know about, which are a minority of cases presented to arbitral tribunals for resolution, are only the top of the iceberg. Beneath that, there are all the cases where states would have liked to move faster on the pathway to energy transition, to do their Energiewende, to use the German expression, and have not dared to do so because of this Damocles sword that the ECT represents for them. And that is huge. These are years we've been losing as a result of this, this threat to have to pay enormous sums of money, again, not only for the sunk investments made, but also for the loss of profit expectations of the companies concerned. So that is what we know and what we would need to document to make public opinion aware of the very significant problem that the maintenance of the ECT still represents.
Aurore, same sort of wrap-up question to you. What impact has the ECT had on climate policy so far, and do we still need it?
On le voit, ça a des impacts partout au niveau européen parce que certains États ont intégré la possibilité d'être attaqués en justice, donc ils vont réduire leur ambition en termes environnementaux. Et après, est-ce qu'on en a besoin de ce traité? On est en train de discuter depuis 1h30 de tous les problèmes qu'il pose et de comment on peut réussir à faire en sorte d'en sortir sans dire qu'on va en sortir et de trouver une solution pour pouvoir s'en sortir par le haut, etc. Et on voit bien à quel point c'est difficile. Ça veut dire que la réponse, elle est claire. Non, on n'a pas besoin de ce traité. C'est un traité d'un autre âge, fait pour une autre époque. Et par ailleurs, je tiens à dire, et je vais revenir avec l'excellente question que vous aviez posée, Jennifer, au tout début, c'est de l'argent public. C'est-à-dire qu'on a des leçons de morale permanentes, notamment au niveau européen, sur la bonne gestion de l'argent public. Et là, qu'est-ce qu'on est en train de faire? On est en train de dépenser de l'argent public dont on a besoin pour résoudre une crise sociale, une crise environnementale, une crise économique. Pourquoi? Financer, protéger. C'est pas de l'investissement, c'est du greed à ce niveau-là. Donc non, je suis désolée, nous n'avons plus besoin de ce traité et je trouve que c'est pas... Je vais arriver sur la question de la moralité, tant pis, mais ce n'est pas moral et ce n'est pas juste de demander aux Européens des fois de se serrer la ceinture sur certains types de dépenses publiques alors qu'on manque d'investissement. Rapport après rapport, on le sait au niveau de la Commission européenne, les rapports du semestre européen sont accablants dans ce domaine. On n'a pas assez d'investissement dans l'éducation, dans la santé, dans la recherche, dans la transition écologique et donc on va payer des investissements qui ne nous servent à rien et qui nous font du mal. Non, je suis désolée, mais ce n'est pas sérieux. Donc non, on n'a plus besoin de ce traité. Merci beaucoup.
Merci à vous. Nathalie, your final thoughts on that as well. Do we need it? How has it impacted us? What's the outlook?
Yeah, I think I can just concur with other panelists, but just to wrap up, I think that if modernization succeeded as proposed by the EU, it would likely still be illegal under EU law, as we heard, and at least as it applies between the member states, but maybe even beyond. It would still allow investors to sue governments, even with respect to existing agreements, with existing investments for another 10 years. So we're worried about the 20 years of the survival clause or the sunset clause, but even under the modernized version, we will still have the possibility to use investor-state dispute settlement concerning investments in the fossil fuel sector for another 10 years, once the modernized treaty enters into effect. So we can see that's if modernization succeeds. And if it doesn't succeed, I do think we heard about option B, that has to be seriously considered. And the survival clause could be dealt with, or the sunset clause could be dealt with, at least amongst the members withdrawing. So I think those are the two avenues, and neither of them are particularly pleasing, let's say.
Okay, thank you very much, Claude. I'm going to go to you last. Looking forward, we have another round on the 1st to the 4th of June, again in July, September, and even in November. Are you going to give us a commitment today that Luxembourg's going to walk away on one of those if things aren't progressing?
Look, I think we have now all understood that I think in June is really where we have to call the bluff. So especially also with those member states or those members of the treaty, which I have explicitly mentioned before. Good, and then yes, I think if there is no movement, then I think withdrawal is not the best option. It's not a super option, but if the treaty doesn't move, then I think there is no choice then to go out with all the caveats, which you have 2 or 3 caveats which remain, which I have addressed before. But I think for that is for me clear. So it's the today treaty is definitely not an option.
Okay, well, we'll have to come back and talk to you then after the beginning of June and see where we're at then. Thank you all so very much for your thoughts, your comments. It's been really insightful. Thank you, of course, to Friends of the Earth Europe and the Climate Action Network for organising this discussion today. And of course, for those of you in the audience, so many questions. I'm sorry we didn't get time to answer all of them, but I hope you will continue the discussion. You can follow along online using the hashtag #ECTDebate, because obviously this isn't over yet and won't be for some time to come. So hopefully we will continue this conversation outside the bounds of today's webinar. But thank you all very much. I wish you a great rest of the day.